If you're a first-time home buyer, your real estate professional is going to ask you this question. How do you want to take title? They're asking because the offer purchase contract asks them for that information. Now, it needs to jive with who's going to be on the loan because that offer contract is going to go to your lender. So if you're the only one who's going to be on the loan, then it's going to be in your name only. And how you take title is something that's really important. So in today's video, I'm going to answer these questions. What does it mean to take title? Is a deed the same as title? Why is the title investing so important? So stay tuned. Hi, Laura Gallant here with Mountain Prairie Living, empowered by ERA Shields. And on this channel, I answer questions about the home buying and selling process to lower your stress. I offer answers, not anxiety. So if you're in the middle of buying and selling your home, or you are a homeowner and you have questions, I hope to answer them here. So subscribe to the channel. So let's get to today's topic. So what does taking title mean? It is describing the right or claim of ownership of that property. So it's defining that you have a right or an ownership to that property. That's what title is. So when you define the type of ownership that you're going to take, and I'll go over the top 5 that you can take, you're defining who owns what percentage. Maybe it's sole ownership and you own the whole thing. Maybe it's sole ownership in a trust. Maybe it's a joint tenancy where it's sole survivorship or tenants in common, and I'll go over all those in a minute. But it defines how the property is divided as far as percentage of ownership. It also defines how that property will be split in case one of you passes away or you both pass away. Here are some key reasons why the title vesting of your real estate is really important. I'm going to read them from this list. Number 1, it helps your survivors know how you want the property to be handled after you're gone. It defines how the proceeds of the property sale should be divided. It can prevent probate. Often a family will place a property in a trust to prevent taxes for survivors and make it easier for them to transfer the title to their ownership upon your death. But it has tax implications for the owners and the survivors. So that's why it's really important that you understand the ways that you are choosing to take title. So what are the 5 most common ways to take title? Now, if you're married, you can take title in what's called joint tenancy. It's the most common use of title when 2 people are married, and it depends on the state that you live in. I'll talk about that one in a minute. Joint tenancy offers the right of survivorship. You cannot divide the percentages. It is a straight 50-50 if it's 2 people, but you can have joint tenancy for more than 2 people, but everything is divided equally, so you cannot make it different percentages. So in joint tenancy, it's survivorship. So say it's you and your wife, and your wife dies, you automatically take full ownership of the property. If 3 of you are involved, maybe your parents are on title and you are on title and they pass away, it would automatically go to you. Now, there would be perhaps some tax implications depending on their will or things that are other additional things that are involved. But joint tenancy is right of survivorship. It's typically done with married couples, and it has equal distribution of percentage of ownership. Common property with the right of survivorship is utilized in states that have common property states, and there's a variety of them. So if you're watching this video, check out what your state offers. But it's very similar to the joint tenancy I mentioned above. However, it has a few differences. One, you must be married to use this form of title vesting. It does have the right to will your percentage to another person. So your heir could obtain part of the property rights after you die if you put that in your will. Tenants in common is being used more often because there's a lot more people who are not married buying homes together. Maybe you're 2 friends going in together because, darn it, it's hard to get a down payment together. So you decide you're going to both invest in this property. You should absolutely have an agreement on the side about who's doing what, where, when, but you're going to take property title vesting as tenants in common. So that division of property can be written out. So one person could be 60% ownership and one person could be 40% ownership, so that they only own the rights to 40% of that property. So tenants in common is being used more often, but it does have the right to the heirs obtaining that person's percentage if they were to pass away without a will. It will go to probate, and that could cause some issues. So if you are going to do tenants in common, you want to make sure you consult with legal counsel as well as a CPA to ensure that if somebody was to pass away, that is outlined and defined for you to prevent any probate issues or any error obtaining that percentage issues that you didn't want. So sole ownership means that one person owns the entire property in its entirety. Now, as I mentioned earlier, you might be asked, who's going to go on title? How is this going to be vested? And initially, you might have a spouse whose credit is not very good. And so from a lending standpoint, it made more sense for you to apply for the loan and therefore you to purchase the property. So only your name will be on the title. That can cause some issues, but I'm going to give you some solutions. But sole ownership means just you own the whole property outright. Now, if you were to die, you would have to have a will to identify where you want those property rights to go, or it will end up in probate. The fifth most common way of taking title is in a trust. And this is often used as parents age because it protects the surviving children or surviving heir who's going to take this property from some of the extensive taxes that may occur. So they'll establish a trust, and the trust will own the property outright. So the trust will define how things will go, as will the will of the people who pass away define how their percentages will go. So those are the 5 most common ways to vest title on a property. So you can imagine that the vesting of title is an important issue. It can be changed by using a deed, but let's talk about what a deed is and what the difference between a deed and a title is. So is a deed the same as title? They're not. What a deed does, it's a legal instrument that is recorded by the county assessor, and it's recording the transfer of ownership. So when you're purchasing a home, say Mrs. Smith is selling to Mr. Rogers. So the deed is the instrument that says Mrs. Smith is transferring the ownership to Mr. Rogers. It's recorded, and the property now transfers ownership to Mr. Rogers. That's the deed. The title defines how that ownership is held. And as I said earlier, it will have a variety of different implications. So I want to talk a little bit more about transferring title. The most common transfer of title besides a loan transaction or a purchase transaction is what's called a quitclaim deed. And you can use a quitclaim deed in a variety of times. So I'm going to go over a few of them now. Now, earlier I said that if your spouse's credit was bad and you applied for the loan only in your name and the contract had to be only you purchasing it, but after that transaction is closed, you wanted your spouse to be on titles in case anything happens to you. So you would use a quitclaim deed to transfer the title from just you, sole owner, into maybe joint tenancy with your wife, so that if anything happens to you, the property will go directly to her so she can provide for your children if you have that. So you can do a quitclaim deed after that loan is closed. What you need to understand, though, is the transfer of title to the two of you does not transfer the responsibility of the loan to her. So you are still solely responsible for that loan. Another way you can use a quitclaim deed, and I used it when I got married, is I had my own house. I sold it, and then I married my husband, and he had his own house, and it was only in his name. I asked to have a quitclaim deed to put both of our names on title. I did not have any responsibility to the current loan he had, but as we moved forward, additional loans that we did had both of our names on it and utilized both of our credit. So we used a quitclaim deed in that situation when you're marrying somebody who already has a piece of property. And the third one where it's most commonly used is in a divorce, but I want to be really clear and caution you. So a lot of times people think that when they've signed a quitclaim deed, that they've released themselves of the obligation of the loan. If there is a loan in both of your names, when you get divorced and it's still due and payable, you are still liable to that loan. Even though you're no longer on the title of the property anymore, you are still responsible to that loan. So if by, say, chance your spouse does not pay the bill, it affects both of your credit, not just theirs. So the best recommendation would be to have that spouse refinance the loan into just their name so that it clears the loan that had both your names on it, transfer the title at that point, and then you're clear of not only the obligations of the loan, but also you're no longer on the title. And maybe that's the way they give you the cash for your percentage that you owned in that property. That's the smartest way. If you use a quitclaim deed, just remember you're still responsible to a loan if you signed on a loan for that property. Thanks so much for watching. If you found value in this video, then give it a like. Subscribe to the channel and share it with a friend. If you'd like to know more about what happens between pre-approval and final loan approval once you're under contract, then check out this video next. Thanks so much for watching. Have a great day.